Hi, Ryan. It's Grant Abbott speaking, and I'm from obviously the CEO of LightYear Docs and also a partner at Abbott-Family legal firm based in Melbourne, but we're practicing certificates all across Australia. Today, we're actually going to look at a brand new product that is adding a reversionary pension onto an existing account-based pension. So I'm going to go through the process of that. I want to walk you through the Commissioner's ruling in 2013 on pensions, when they commence, when they cease, the absolute importance of a deed. I read a case just recently, in fact, it's from the Victorian Supreme Court in 2020, where they had a look at the importance of the deed, how to read a deed, and more importantly, how to construe the deed. And this was in relation to variations of deeds. And I must admit, the variation clause there was absolutely abominable. It had it was one sentence, had over 350 words to it, and it's unbelievable. Anyway, today is all about pensions inside self-managed super funds, and it's absolutely vitally important because this is an absolutely crucial part of the estate planning for our clients. So when we have a look at it, reversionary pensions started life as annuities hundreds of years ago, way back to the 16th and 17th century, as a form of reward for soldiers who fought for king and country in England. Now, if our valiant soldier made it back to his beloved country, the king would provide him with a lifetime annuity, and if the soldier died, it would continue on in the name of his wife, and we call that a reversionary annuity. The same system operates for our current parliamentary pensions. So they are actually paid out of consolidated revenue and they're governed by the Parliamentary Pensions Act, I think. So they're specifically named. And then when our politician dies, then I think it's around about 75% of the income that was being paid to them goes to the wife for life. So that is obviously a very tight characteristic in terms of reversion. So it can only go from politician down to their spouse. So if the spouse is not alive, then obviously the annuity ceases. It doesn't go down to their children or alternatively grandchildren. For those of you planners out there, and I saw Brian over there in Perth, and I know you've had a lot of experience in this area, but when you have a look at some of the Commonwealth Government public pensions particularly, and the old defined benefit pensions, they are of a similar ilk. So it goes from the main pensioner and then automatically reverts to their spouse should they be alive. Now again, and I want to emphasise this, if they are not alive, then the pension dies. If you don't have a reversion, and I'll show this a little bit later on, and the member dies, the pension member dies, the pension ceases. Does that make sense? So all you have to know is just remember that if there is no reversion, or you've got a pension without a reversion, which we're going to look at a case study, the pension ceases. That means there is no more pension there. And I'll come back to the absolute consequences on that. Now, the SMSF level, the Commissioner of Taxation in his ruling, provides that the type and style of pension offered is dependent upon the trust deed and the governing rules of the fund. So when we have a look at it, section 10.1 of the SIS Act details governing rules. And for those of you who have been with me before, been through my training, the governing rules are all important. They include the trust deed, any written or unwritten rules detailing the operation, establishment or maintenance or management of the fund. So hence, when we complete a pension form, or we effectively enter into a pension contract with the trustee of the fund, that binds the trustee. And that's absolutely critical, because if there's any breach of those rules, whether it's by the trustee, whether it's by an executor who might just happen to one of these particular pensions, or for example, can you countenance that we might have a trustee, might be the second wife, for example, and we've got the original member who's died and reverts the pension to his first wife or his first children for that matter, and then the trustee of the fund ceases that, then effectively we've got a breach of the governing rules, because that continuation as per the contract hasn't been taken into account, and accordingly the reversionary beneficiaries may sue the trustee of the fund. And of course you'd have to watch out for any accountants or auditors who are cognizant of that fact and letting that termination go or have advised on it, can sue all of those parties under section 54C and section 55(3). So knowing what is in the deed is absolutely crucial. You cannot, under any circumstances, add a reversion to an existing account-based pension if the current deed does not allow it, or the governing rules, which essentially the pension documentation, does not allow it. For example, you can't add capital to a pension because that's a breach generally of a deed, and it's also a breach of the SIS regulations 1.0691. So we've got to be very careful about that. So importantly, any pension documentation or addition of pension, as long as not capital, will form part of the governing rules of the fund. And that is backed by the SIS Act, a statutory strict liability of suit if those governing rules are breached, and that's absolutely crucial. I'll come back. And potentially also if there has been a willful breach, for example, in that first instance I talked about where the second spouse ceases and has profited from it, effectively there's potentially a jail term or imprisonment under section 201C of the SIS Act, as well as also the Commonwealth Crimes Act, which also provides that any lawyer who advises on that, or accountant, etc., is also caught for aiding and abetting that breach of the Commonwealth Crimes Act. So again, the thing there is not to scare you, is to show you how powerful the documentation that you make for these clients, absolutely crucial. Tony, there will be a copy of this video available later on today, along with the slides, along with the Commissioner's ruling, and also along with the pension documentation as well, just in a draft form. So let's go through, because we're going to get to the end. We want to look at the law, we want to do a case study, and then we want to actually see what it looks like in practice. So ask questions as you go along. Now, importantly from this one, and there's been a lot of conjecture in the marketplace around this, about BDBNs and reversionary pensions. And I want to put it all to rest for you now and show you it's absolutely disastrous that if we let a BDBN override a reversionary pension. So anyway, there are no SIS Act or SISA. So this is actually from the Commissioner of Taxation, the 2010 NTLG meeting. So this is not me, it's the Commissioner. Let me just get my little bouncing ball so I can spotlight it for you. So there are no SIS Act or SISA provisions that are relevant to determining which nomination an SMSF trustee is to give precedence where a deceased pension member had both a valid reversionary nomination and a valid BDBN in existence at the same time of the member's death. Now, as soon as that, if I see that, I know there's conflict there, so that's a danger. Now, here's importantly, while Section 59 of the SIS Act and Regulation 617A of the SISA place restrictions on super entity trustees accepting BDBMs from a member, as explained in SMSF Determination SMSFD 2008/3, and also the case of Donovan, the Commissioner and the courts are of the view that those provisions do not have any application to SMSFs. So, for example, if your deed provides that a binding death benefit nomination can be provided to the trustee of the fund, provided it's in accordance with SIS Regulation 617A, then it is void, because 617A does not apply to BDBNs. So that's very crucial. And you'll find in the Commissioner's ruling in 2008/3, it's determinative by what the trustee requires. Now, it also must be remembered that Section 59 of the SIS Act and Regulation 617A of the SISA are necessary because of the general trust law principle that beneficiaries cannot direct the trustees in the performance of their trust. The ATO's view, which I agree with, is that a pension that is a genuine reversionary pension, that is, one which under the terms and conditions established at the commencement of the pension reverts to a nominated or determinable beneficiary, must be paid to the reversioner. It is only where a trustee may exercise its discretion as to which beneficiary is paid the deceased member's benefits and the form in which the benefits are payable that a death benefit nomination is relevant. Does that make sense? So effectively a reversion, if there is no reversion, then it goes back obviously to the BDBN. But if the reversionary pension beneficiary is dead, then it goes back to the BDBN. Now notice this from the Commissioner, and also going to look at his guideline, is that if it ceases, then it goes back to the accumulation account. Work on that one. If the pension ceases, unless there's some other terms and conditions that are built into the trust deed and the governing rules, that effectively that pension ceases and goes back to the accumulation side. Now, more importantly, if someone dies, it may well be the case that the trustee provides that membership ceases. So just let me put it to you. What do you think happens inside a self-managed superannuation fund? And this is particularly important for all you accountants and administrators out there. What happens inside that fund if we've got mum and dad and maybe a child? It doesn't really matter about that, but dad dies. So dad dies and the deed itself says that membership ceases. What should happen in that instance? What do you think? So let's say we've got, a couple of $1 million of assets. Dad had $1 million in a pension. Primarily it was just sitting there. Effectively, dad dies. We look at the deed and the deed says the membership ceases. Now, of course, we're going to go down the track and that $1 million could be paid to the spouse, could be paid to the estate, could be paid out to one of our special purpose SMSF testamentary trusts that the trustee of the SMSF creates. And I'm going to do a session on that in a couple of weeks, and I'll talk about that a little bit later on. But effectively, here's the important point for all of you. If your deed says that membership ceases, you must take that amount and put it effectively into a sub-fund, whereupon no earnings and also no expenses can be charged against that account unless it's authorised under the deed. Now, if membership ceases, that's the end of the story. And what it means is that any earnings on that $2 million, because effectively what happens is when membership ceases, we take a snapshot at that point in time, and now that amounts to being a debt due to our executor, the recipient, whoever's receiving that lump sum. Remember that pension ceases. So that any earnings on that must go back into the fund for the other members. If it is paid out to the deceased estate, to the spouse, even $1 above that $1 million, effectively there's provision by the trustee and the members of the fund to recover as against that estate for any loss of monies going out or damages because the account balance that's been paid out to the estate or the spouse is greater than $1 million. Whether that happens in practice is another area. Now, I just want to cover it, and I'm going to go to the next slide first, because it's really important here, is that under the governing rules of the LightYear Docs SMSF trustee, and also for those of you who are looking for a bloodline specialisation, our leading member SMSF deed, effectively, and this is important, if a member dies, their membership does not cease. Listen to that one. If a member dies, their membership does not cease. In effect, if they're receiving a pension, but obviously not a auto reversionary pension because that would pass on directly to the next person, the next reversionary. But if it's just a straight pension, then it continues on in the name of the deceased member, but the benefits are to be received by the legal personal representative of the deceased member's estate, which is the executor. So effectively, the executor stands in the shoes of the deceased member. And it's also important when we have a look at that there's a successor director solution also involved in this process, and even better still, a leading member solution such that the executor is automatically appointed as a director. Because you can see under the special purpose LightYear Docs, SMSF corporate trustee, if you have a look at the director, the executor is automatically appointed as director, and particularly if you've got the successor director solution, and they are the only ones who can make decisions around the death benefit payments. So it puts all the power and control in the executor, so there's certainty. Can you imagine if you didn't have that? Going back to my first example, where you've got the spouse from the second marriage who wants to freeze out the children from the first marriage. And I think that's absolutely crucial to maintain that control. So let's go and have a look at some of the legal side of the, let's go and have a look at the legal side of an auto reversion. First off, it must be built into the pension documentation provided the trustee allows. It's a contract between the trustee and the pension member and the reversionary beneficiary. So what will happen is that effectively in your accounts and the administrators, if we've got a valid contract, and so it goes, for example, to John Smith, who's obviously we've set it up, and John has then got a reversionary beneficiary being Sally Smith. On John's death immediately, that pension ceases in his name and is transferred automatically by way of book entry to Sally. So Sally will now have a pension. If she's already got an existing pension in there, then we need to set up another pension account for Sally, or alternatively, just convert John's pension account to Sally's pension account, if that makes sense. Now, we're going to have a look at a little bit later on, but if we have a look at the spouse there, and interestingly, anyway, no, I won't go into that. It's contingent, obviously, about the reversionary beneficiary being alive at the time. So when we have a look at that, if Sally's not alive, then the pension ceases under the LightYear Docs deed. Obviously, the pension continues in the name of the deceased member because their membership still is in existence, but the LPR or the executor of their estate is prima facie the deceased member, which is exactly what happens from a taxation perspective for those of you who've ever been an executor. You are treated as if you were the deceased carrying on life as a taxpayer, getting all the rights and entitlements that an individual taxpayer will have. But if a reversionary beneficiary is, if we look at the deed and it says membership ceases or the pension ceases, first off, if the pension ceases, it goes back to the accumulation account. Secondly, from that one, if membership ceases, then effectively it must go into a sub-fund. Now, let's go and have a look at the other scenario that we have a pension and we want to, we're going to cease it. And we'll have a look at that in a second by going into Commissioner's ruling. Now, in terms of your TBAR, what happens there, and this is important, that if it is a reversion to Sally Smith, remember that auto reversion, we change the administration, the name on the pension, it carries on in the name of Sally. From a perspective is up to the date of the pension being transferred, we have to ensure there's a minimum pension paid for John, and that would then go obviously to the estate. So make sure that payment's made. In terms of Sally taking over, if she takes over for part of the year, we'll be using her minimum pension valuation factors to address the minimum on a proportional basis during that year. Now, an auto reversionary to a financial dependent is allowed. And we go down that track and we have a look. If we have a look at the SIS regulations, Regulation 621 requires on death of a member that their benefits must be paid out as soon as practicable. Importantly, from that perspective is when the member dies, that component, for example, the $1 million that John had in his pension, ceases to be impacted by 621. We have to, though, go to 622 and have a look at who can actually be in receipt of the pension. So if there is no reversionary pension, we've got to go in and have a look at who can be a recipient of that reversionary pension. And in that regard, it can include a spouse, it include an adult child. However, if it goes to an adult child, if this is a reversionary pension, and this is either up front, then there has to be a commutation of the pension. So that's pretty important. and that will go out to the adult child. And I'll look at that a little bit later on when we start looking at our case study. The alternative is, that's if it's a child. If we have a financial dependent, such as a brother who's financially dependent, either partially or wholly on the deceased, for example, John Smith may have his brother, Bruce Smith. If he's been looking after Bruce Smith over a period of time, either as a financial dependent or by way of an interdependent relationship, then that pension, that reversion, can carry on in the name of Bruce. We need to show that relationship, that dependency, the financial dependency, the interdependent relationship at the time of death, whether Bruce can then take that up. And again, this is if the reversionary is built with Bruce in mind. Alternatively, if there is no reversionary, then we can still pay a new pension to Bruce if we can show that he's financially dependent at that time. But of course, there might be a bit of space between that actual payment and the death. Auto reversionary, straight like that. But for Bruce, obviously it's not going to be the case. The same with grandchildren. Anyone else who happens to be in the bloodline, even friends, which obviously I don't count, and so don't think that that's appropriate unless your client has specific circumstances. They don't have any children, they don't have any spouses. They may well pay it to a friend, brother, uncle, auntie, parent, or whatever. But again, we need to show that they're financially dependent. And that's the benefit of the family allowance agreement that sits on the LightYear Docs site. Absolutely crucial. If you haven't seen that, go and investigate it. Every one of our documents on the LightYear Docs site has been built special purpose and, more importantly, from a high-level helicopter strategic point of view. So when we go down there again, we can have a position whereby a grandchild, for example, if they're financially dependent on death, they could be a reversionary pension member. So it could go from John Smith down to a grandchild. Now, you might be saying, well, why wouldn't it go to Sally Smith? Now, I'm finding more and more, and I'm sure you guys are as well, we need to be really careful around our estate planning, our pension planning for Social Security purposes, because it's going to be included as part of the assets test. Likewise, we may have an instance whereby our estate plan or our bequests to our spouses are part of our estate planning, may be included in the assets test, which may severely impact their Social Security, their welfare, and also obviously any aged care, where that obviously they'll have to start paying a daily amount if it's not subsidised, if they're not under that assets test. For estate planning, we can in fact renounce some of our bequests if we want, to make sure that we stay under those assets, provided of course our will allows. So let's go on and have a look at these last four bits before we bounce into the Commissioner's ruling. So for an adult age, what happens for an adult child age 40 who's a non-dependent receipt of the auto reversionary pension? Well, as I said before, what do you think happens? So it could go from John to Max, his son. But Max is 40. He's a dependent for SIS purposes, but he's not a dependent for tax purposes. So the question is, can that pension continue to be paid in the name of Max? Well, the pension can't continue under 622 of the SIS regulations. So what will have to happen there is the trustee will be able to pay it to Max, but it'll have to be a commutation payment, a lump sum payment. Now that's important because instead of going out to the estate, the monies can be paid to Max. And then from that perspective, Max can then take those monies. Ideally, it'd be fantastic if there was a family allowance agreement and Max, just the same as his uncle Bruce, was living on John, then that would come out tax-free. Max then can either take the money directly, could put it over to the estate in a super proceeds trust, but why would you do that when you've got the money and effectively it's not going to be subject to any family provisions claim? So he could take it, he could put it into a special Section 102 AG4 testamentary trust from superannuation proceeds. So rather than going through the estate, it's protected and the SMSF would create that along with you as the advisor. Or could go into a family protection trust or any other trust or company. depends on where he wants it to go. So he'll be directing where those monies goes, which is important. Again, he can't take the pension. If he's age 20 and is financially dependent, absolutely, he would be able to continue that pension up until age 25, whereupon again it's required to be commuted, and then we go through that whole process again. You can either take it directly or put it into a trust. Again, any grandchildren in my lineage at the time of my death who are dependent, again, you could have a situation that goes from John, doesn't go to Sally. And why is that? Because Sally's got too much money for Social Security purposes and doesn't want John's money. We don't want to pay it necessarily to the children, because obviously they need to commute it and take it out, which may create obviously some, if they're in bankruptcy or family law issues, that could create an issue there, because it's got to come out to them and then they transfer it on. So that micro nanosecond that comes out to them, that's when a family lawyer, that's when the trustee in bankruptcy can start to attach it. Although, can I just mention this, there is a famous case, Morris and Morris, that the trustee in bankruptcy was precluded, listen here, the trustee in bankruptcy was precluded from taking a death benefit lump sum. So anyone who's got problems with trustee in bankruptcy of deceased estates must ensure that money goes out by way of a lump sum, and that is in Morris and Morris. So for grandchildren, we could simply put in a proviso that the pension is to be split amongst all the grandchildren who remain alive and financially dependent. So you may end up with a pension being split like a tenants in common partnership over a period of time. So let me just go through. We've got a Ken race. So for non-tax dependents, a reversion pension may be better, where a BDBN, which would be taxed absolutely perfectly. So if we have a look at non-tax dependents, you're better off, because that's absolutely crucial that you raise that, Ken, is that if, and the way it works, if the original pension member, and I'll say this again, if the original pension member is aged over 60, then all the reversionary beneficiary recipients, whether it's Sally, whether it's Bruce, whether it's Max, or more importantly, John's grandchildren, who are Max's children, if it ends up there, it will always be tax-free. Oh, here's another thing. By the way, if it goes to grandchildren, it's not the 25-year-old. Remember, I talked about Max being age 20 and has to take out age 25. That's only for children. So the grandchildren's pensions can continue on until the money runs out. And we know what grandkids are like today. It's probably going to be about 3 years. Can I do a decision flow chart of the different scenarios? That's a good one, John. In fact, what I'll do is, because it's recorded, I'll get one of my team to do a decision flow chart on this, which would be a useful tool for your perspective. And you can start to see all the little nuances and the intricacies there, and the huge value that we can have there for our client. Even Ken, and let's give a hat tip there for Ken, who's come along and basically said, well, you know, if you're going to be worried about doing those, you know, those monies coming out, if you can get it to someone who is a financial dependent coming out, or getting out that pension side, it's much better. So let's go on and have a look and do a deep dive into the Commissioner's ruling. And then we're going to look at the LightYear Docs deed, and then we're going to have a look at a couple of issues there. So don't worry about those last two. They are from our next slide when we get down to the case study. So the thing I want to look at is, first is the Commissioner's ruling. You'll find this is actually sitting up on our site. For those of you who haven't seen in our site, we've got quite a lot of articles around all of these particular issues, where someone puts in a support ticket and I feel it's worthy of putting up on the site, then I put into the technical section. So I'll just show you where that is on our site, and then you'll have a good idea. So if I look at the publish now, so you can see that this article, and I'll go through there, when does a pension commence and cease? So for example, I'm starting to put up all my tax rulings, cases and everything up here because it's a lot easier for me to go in and find the data, the cases and everything here from my own perspective, rather than having to go through either Googling the tax office website or, more importantly, my hard drive. So we've got here, when does a pension commence and cease, which I'm going to have a look at. For example, stamp duty on transfers of property to an SMSF. We've got built into our deeds now, our SMSF deeds, is the ability for both Western Australia and also New South Wales to segregate assets built within those funds for concessional stamp duty, 0 over in Western Australia and 500 in New South Wales. Is a change in appointment as trustees, beneficiaries or vesting date of discretionary trust resettlement? No, and you can see there that's from the tax office. But we want to have a look here at what the Commissioner says. So essentially this is, when does a pension commence and cease? So when we go down here, and let me just put it up because I'm not sure if your vision's as good as mine. What is an income stream? What's a superannuation income stream? Superannuation income stream, it talks about you must have obviously an ongoing stream. You can't just have one pension and it ceases. When does it commence? That's obviously here. It's going to be between the terms and conditions between the trustee of the fund and also the member. Now, when a superannuation income ceases, a superannuation income stream ceases when there is no longer a member who's entitled, or a dependent beneficiary member who's automatically entitled to be paid a superannuation income stream from a superannuation interest. So that's a reversionary. When a superannuation income ceases, this is important, is determined by reference to the particular super fund's governing rules. We've talked about that. The requirement of SIS Act, the Regulation 94, and the facts and circumstances of the payment of the members or dependent beneficiaries' benefits. So the typical ones are failure to comply with the pension rules. So if there's a minimum pension payment which is not made, then effectively, and listen to this, that pension ceases. So effectively, it rolls back to the accumulation side and may start up again. The danger about that, and if you can consider, let's say we've gone to the brilliance and built a pension which is primarily tax-free, which is fantastic if it's going to go out to some of our non-tax dependent beneficiaries. They'd love that. But on the other side, we've still got our accumulation account, which has really got a lot of taxable component. Well, here's what happens. If you don't make that minimum pension, then effectively your pension payment goes back to the accumulation, gets mixed up with all of the other components. So then if you start the pension again, it can no longer be primarily tax-free. It is going to be what the proportion is at the time of commencement of the pension. So be very careful. Now, just on that one, also you'll find in our account-based pension documentation in our governing rules that there is an ability to tick a box when you're doing the account-based pension that provides that if a minimum pension has not been provided by the trustee to the member, there's deemed to be a promissory note. So an amount owing by the trustee of the superannuation fund down to the pension member. It covers all the nastiness around here. But again, you've got to be watchful of that because that promissory note can't go for a long time. It's really on demand. Exhaustion of capital, that's fairly obviously. Commutation, have a look there. You've got to be really careful. For example, if you are going through that commutation, and I use this, remember the instance I said that the LPR effectively is going to come in and look after that pension if there is no reversionary pension under the LightYear Docs deed. Importantly, from that perspective, if the LPR commutes all of the pension or takes it all out as a lump sum, then that pension ceases. Now, the whole idea is you can keep on commuting, do partial commutations along the way, and the pension will still retain its character, which is important. Now, this is the one, death of a member. A superannuation income stream ceases as soon as a member in the receipt of the superannuation income stream dies, unless a dependent beneficiary, the deceased member, is automatically entitled. Remember dependent there? Spouse, child who's financially dependent. Under the governing rules of the super fund or the rules of the super income stream to receive an income stream on the death of a member. If a dependent beneficiary of the deceased member is automatically entitled to receive the income stream upon the member's death, the superannuation income stream continues. If we don't have a reversionary or the reversionary is dead, then again, what happens to it? That's right, it goes back to the accumulation, mixes up with all the other amounts there, and then even if the spouse, or remember, brother Bruce gets a brand new pension out of that whole deal, it's going to be mixed up and the componentry is going to be whatever happens at the side. So you can see why I love reversionary pensions, because they're virtually, there's nothing involved there. And more importantly, they can't be, and here's the important thing from an estate planning, they cannot be attacked from a family provisions claim, because they've gone, as soon as the member dies, bang, that is the end of their entitlement. That's the end of their pension. They don't have that asset in their estate. It's automatically transferred to the next person. So again, I just think it's a bit of a no-brainer. I want to go and have a look at our deed, which is pretty constructive on this whole process. So this is an upgrade to our deed. We've got a lot of stuff going on in here, full of strategies, absolutely way to go. And we continue to change it all the time. So you can see here, we've got, in fact, I'll just see here just to show you, trustees and investment monies, investment strategies, so on and so forth. We keep on going down. So what we want to do is look at benefits payable by the trustee of the fund. Now, obviously, accessing member benefits, you need to be retired, transition, that's all up there. You can have a look at that. Now, subject to the super laws and without limiting the powers of the trustee, the following super benefits or other benefits may be made by the trustee at the member's request. So we've got temporary incapacity, and I've been through that before. Permanent incapacity can take a superannuation income stream. Terminally ill, the same sort of thing. Members retired, you can take a superannuation income stream, so on and so forth. And there's a whole set of conditions around that. And look, really, it's even the commencement of payment income stream, which meets the condition of income stream payment, which is that's a salary continuance payment, which is allowed under there as well. So what we need to do is go down to the definition of superannuation income stream. So where it's highlighted, and this is where your assessment needs to be. So we go down to superannuation income stream. I'll just blow this up a little bit further so you can see. You might have just actually gone as we went through. It's not the time here. You might have just seen the definition of promissory note in there, which is really important. So superannuation income stream includes, subject to super laws and the fund retaining its complying status, a series of periodical payments created by the trustee for the benefit of a fund member or any other person, and shall include conditions relating to the term of the stream or pension, the quantity of the payments, any indexation, the other factors to be applied to the periodical payments, and when or whether the income stream is commutable, has an automatic, as we said, reversion, or is capable of being transferred upon the death of the member, including conditional reversion pension, which is subject to conditions, which we'll show, or pension that has a residual capital value, which is a lump sum at the end, which you can effectively do. The super income stream also includes, amongst other periodic payments, the following, subject to terms and conditions of the law. Obviously, we have a look through there, so just any pension, lifetime complying, accountants based. Now, notice how specifically we've got in here that it can have a reversion. If your deed does not specifically provide for a reversion, because the laws, if you have a look at the account-based pension, doesn't talk about reversions, then you cannot offer a reversion under those circumstances. So we go down and have a look at that. Let's go and have a look at what the definition of pension is, and then we'll go into a case study and start building some stuff for you. So if we have a look here, oh, sorry, what am I doing? Silly me. Sorry about this. So we're going through pensions, SMSF living will. So 6.7 here, I've got here also income stream and pension rollbacks plus transition. So in that instance, what we can do is we can roll back the pension and commence it again. But what we've done now is we've also added the ability here under 6.7 of the trustee, which becomes part of the governing rules of the fund. Where a pension does not have a reversionary pension member, the member may, with the agreement of the trustee, add one or more reversionary pension beneficiaries, including relevant terms and conditions to the existing pension, without becoming a new pension, but a variation of the current pension. And that's important because we need to go in to our existing deeds. And I've got, for example, here a fairly famous deed here, which talks an account-based pension. It looks at, can it be transferred? A lot of this stuff just comes straight out of the regs. And the problem about that, let's have a look to see if there's a reversion. So can it be transferred to another person other than to a reversionary beneficiary? So thumbs up, we can do reversionary beneficiaries with this particular pension, which is good. So what I'm looking here is to see, is there anywhere else that I can add reversionary beneficiaries? Because I need to have something specific within the legislation or my governing rules. And I can't see anything in there at all that enables me to add a reversion. So what we need to do is we would need to then go ahead and update the deed, which is pretty crucial. I've got a couple of questions here, and then what I'll do is I'll then go in, we'll have a look at a case study and see how the system works. So Ashok, can we add reversionary clause in existing pension agreement with new minutes or request by a member? The danger about that one, Ashok, is that it's funny when you have a look at, obviously there needs to be an application by the member to the trustee of the fund. New minutes, absolutely you can do that, and I'll show you what the LightYear Docs solution is. But you need to go back to the start and make sure that your existing deed allows that to happen. Good question though, and we'll have a look at the solution in a sec. What's the impact when a deceased pension reverses to the spouse and make the spouse's total pension balance exceeding? That's a fantastic question, Anna. So that, for example, if our deceased is over the pension cap, and let's say they've got $2 million, then under the TBAR, you've got 12 months to choose. And this is only for the spouse, not child beneficiaries or the brother like Bruce. You've got 12 months to choose what to do. Importantly, from that perspective, unlike the old days, you cannot roll back that pension to the accumulation account. She would either keep it going on in her own name, and within 12 months, that would then be tested as it was way back at the time, 12 months earlier, at the time of the deceased, at the time of death. But the main thing is if she's got an existing pension, then effectively what we can do there, I'm going to show you two solutions. She can roll back her pension to the accumulation side, and then effectively what we would do there is we continue on the pension, which was her husband's pension. So because that's the only one tested, not the one that's rolled back. Now, the amount that's rolled back, it might be an idea to actually pull that out of super, because obviously it's going to come out tax-free, and put it into a family protection trust, because we don't want her to die the next day and then find out if we haven't got any financial dependence, it's going to be taxed at a rate of 17%. So when we start to look around those abilities, there's a lot of flexibility going on down the track. There's also, if you do have social security concerns, I just want to look at the lower end, so we're not looking at TBAR. If a reversionary pension comes, you can always renounce that. Provided it's under the deed, you can renounce your entitlement to that reversionary pension, which means it stops there, and then it's up to the trustee of the fund to make a decision around that one. So let's go back to the slides and have a look at a case study. So I've got John Smith is 70 years old and is married to Sally, who's age 58. John has a pension with a TBAR of 1.4 and no reversion. Sally has an accumulation account of $650,000. John has two adult children, Sebastian and a estranged daughter, Marie, who's threatened to go to court for John's money if he leaves to Sebastian. Sebastian has two children, Marco, age 9, and Polo, age 7, for which John pays school fees. So that means potentially they're financially dependent. What do you advise? Well, I think there's a lot of solutions there. The first, and what I always do these days, is do you want to ensure, John, that this income is protected for your bloodline and is not dissipated in legal fees? And I would say that John's going to say absolutely yes. So the first thing is we need to build reversions in there, because if this ends up in the estate, remember when John dies, what happens to his pension? What does the Commissioner's ruling say? That's right, it goes back to the accumulation side of the fund and there is no pension amount anymore. Potentially, it could go out to Sally, or a brand new pension could actually be started for Sally at that instance. So again, that's not a bad idea, but that's not going to help the estate. Does that make sense? Because if Sally folds the next day and the money's end over in the estate, bingo, bango, bongo, and Marie's going to attack it. So that's the beauty of the reversionary pension. So perhaps we have John, and then it reverts to Sally, and then it reverts to the grandchildren, because that takes Sebastian out of it. And obviously, if you take Sebastian out of it, then Marie's, there's not much that Marie can do. We can put the two grandchildren in there because they're financially dependent upon John. Now, of course, I just go back to the issue that was raised before. If we've got that $1.4 million, which is sitting in the existing pension, we've got 1.4. Now, he might have $2 million in there at the moment, but it's still 1.4. All we're going to do is add a reversionary there to Sally. So the benefit for Sally is going to be likewise. So let's go in and I'll show you where to look. So I'm just going to open up the LightYear Docs site, and you'll see here, I'll go to the documents itself. And in the documents, you'll see I go down here. We've got a whole range of estate planning, a whole range of companies, loan agreements, commercial, income streams, obviously. So I'll go in there and I'll put SMSF income streams, and you can see there we've got temporary incapacities, TRIS, we've got fallbacks, but I'm going to use this addition of a reversionary pension. Now, this is $295 because it is quite a significant estate planning tool, and that's absolutely crucial. But more importantly, you're going to see when we get into it, it also includes an upgrade of the deed so that you don't have to go through the process of working out whether it's going to work or not. So I start the document, and it's now 12:19, so I'm going to show how quickly you can go through there. We've got the Abbott test. So I'm going to put here John Smith reversionary pension. So that's okay. And then that will come up, and that will now go into my system. So we're now going in. A lot of people ask, well, is this the provision of legal advice? No, because essentially you're just completing some fields here based on an Abbott-Family template, which has been signed off for you. So if there's something wrong around the template when it comes around to a review by a court, etc., then Abbott-Family wears the circumstances. However, if you use the document incorrectly, for example, we're trying to add a reversion and you choose the TRIS, then obviously there's an issue there for you. And that's why we have the disclaimer, to make sure that you choose the right document. Now, what we can do is we can put either your logo on, but because we're adding reversionaries and it's estate planning, and we know that Marie may be litigious, I would go and put Abbott-Family in there as the logo, so it comes out on the Abbott-Family. Do you like our little logo there at the back? So the fund, this is pretty easy. As you're going to see, it's pretty easy until we get there. So the Smith family super fund. Now we then go down to the member, who we know is John Smith. Member's date of birth. So it's going to be 01/ oh, see, I can't even get it. Sorry about this. 01/ sorry, it's 12/1970. So that would be, what's that? 19. You guys are probably laughing at me going 1941. I don't know, is that? Nope. So 1940. So there we go. So he's 70 years of age. What date will the member be making this application? Let's say it's tomorrow. Now, highly advisable to upgrade. Do you want to upgrade? Absolutely. So you make your choice there. We're going to do an SMSF deed of variation as well. So why not upgrade? That's part of this package for the client. Not only are you going to ensure that you've got some great estate planning, you're going to mitigate taxation on the whole deal, plus obviously protect for a family provisions claim and upgrade the deed as well to 6-member funds or whatever. So it's pretty valuable. What should be charging around this? Well, from an estate planning perspective, I'd be charging at least a couple of $1,000s for this. The value there, I'm sure, If it was a couple $1 million that we're talking about, we probably would go a little bit further. And I'm sure my good friend Tim would probably charge $4,000 to $5,000 for this. And you know what? It's worth every cent, because without this, Marie is going to take you to court. And more importantly, from that perspective, and I'm going to show you a lot more importantly, from that perspective, you're going to be waiting for it for 3 or 4 years, and it's going to cost at least $150,000 in legal fees. So I'd be very careful about that one. So we've got 2 directors at this stage, John Smith, and then we've got Sally Smith, his wife. I'd probably, if we're going to make the payment, I'll show you a little bit later, to Max, I would bring, so Max's children, I would bring Max in. Okay, so here, I'm going to come back to this. I'm just going to jump forward if you guys don't mind. I just want to show you, and yeah, Tim says too, right, and he is right, that if you're looking at this, I think it's a good $5,000 to $10,000 deal. I just want to go through and just show you how quickly we can do, this is the trustee meeting. Obviously, it's going to be tomorrow, John Smith, Sally Smith. And all you have to do is just select, the address is already in there, so that just populates. What I want to do though is I just want to get the trust deed going here. So when was the fund originally set up? So 01 slash, oops, sorry, slash 10 slash 2012 or 2015. Has it been varied before? No. If it is varied before, you just put in the variation dates. We're going to go no. Voting rules. So we've got a corporate trustee, but if that corporate trustee is removed, how do you want the individuals or the trustees to vote? So I'll just go proportional. Deed of variation, I would go down and say, okay, well, let's look, we're coming up from this deed here. Definitions, we're looking at upgrading the deed to a better deed, of course. I can't even read half this stuff, it's just crazy. Variation, the trustee may at any time by deed or written resolution vary these governing rules. So I'm going to go back there and it is 24.1. Do I need a principal, founder, or another person? No, because it just says a trustee, and that's it. So now I'm going to go in the reversion beneficiary. So what I've effectively done is I've done a document there. Yes, so David, absolutely. The fees is at expense of the SMSF. A bit of both actually there, but primarily most of it would be for the trustee of the fund, because we're doing a deed upgrade for this specifically. Now I want you to focus in. This is the focal point. This is the real deal that we're going here. So we put in the name of the beneficiary. So we've upgraded the deed at the moment, so we're happy with that one. And we know under the deed we can put a reversion. We know we can add it to the documentation. So effectively this is getting rid of the old document. So we've still got the old documentation and then we've got the new. If you want to go back, if you feel the old documentation is deficient, then what you'll do is you'll do a rollback and then a recommencement of the account-based pension. But if you're happy with the existing pension documentation, then you do this. Now there's 3 circumstances that you need to look at. And this is the same when you do a binding death benefit, or what we call an SMSF will. So first one, in the event that the reversionary beneficiary, oops, sorry, silly me, Sally Smith. So the event that Sally Smith remains alive at the time of your death. So what will happen here is I've pre-formatted. I've put in there what I believe should be in there. I'm going to just take you through a couple ones. So the first thing is that in the event that John Smith remains, sorry, actually it should be Sally Smith. Let me just go back and get rid of that one because it's coming up a little bit wonky. But again,